So what I'd like to do now, we're going to be structuring our conversation today in two sessions. That's really just to kind of group our thoughts and kind of build a little bit as we go through the roundtable today. But before we start, I just wanted to introduce all our roundtable participants who will be joining us throughout the sessions. And I'm just going to give the briefest of introduction, but I encourage you to look, and you'll see in the notes on the screen, the Q&A, you can see the link to the Corporate Crime Observatory, where you'll be able to view full information on this session, as well as the biographies of our panelists joining us today. So I wouldn't want you to miss on all the details, so please check that out. But briefly and in alphabetical order, Scuola Superiore is an investigative reporter and video journalist for the International Consortium of Investigative Journalists, ICIJ. Amedeo Bartletta is a lawyer and researcher specializing in transnational criminal law. He serves as vice chair of the European Criminal Bar Association. Mario Bendoni is a public prosecutor at the Court of Turin, and for almost 10 years has been dealing with bankruptcy, corporate tax evasion, and money laundering offenses. Italo Borello is staff director at the Regulation and Institutional Collaboration Directorate of the Italian Financial Intelligence Unit, FIU. William Borden is a prominent European lawyer specializing in human rights who's represented several top whistleblowers. He serves as chair of the Platform to Protect Whistleblowers in Africa. Simon Bowers serves as investigations editor at Finance Uncovered, an organization that aids investigative journalists in challenging environments. Alessandro Butecci is a journalist and former general of La Guardia di Finanza and head of unit at the European Commission. He designed the European Anti-Fraud Office's Anti-Fraud Communicators Network, and on its behalf signed a memorandum of understanding with the International Federation of Journalists. Stefano Castellani is a European delegated prosecutor at the European Public Prosecutor's Office for the Court of Turin. He previously served as a member of the Anti-Mafia Directorate and has acquired over 2 decades of experience in investigating organized crime and economic crimes. Mihail Ivanov is the liaison prosecutor for Moldova at Eurojust. His experience includes working as a prosecutor in the Moldovan Anti-Corruption Prosecutor's Office, where he focused on cases of tax evasion, money laundering, and corruption. Tom Devine, since 1979, has been the Government Accountability Project's legal director, where he has assisted over 8,000 whistleblowers. Veronica Dragolin is the chief of the Anti-Corruption Prosecution Office for the Republic of Moldova. Samantha Feinstein is the staff attorney and director of the International Program of the Government Accountability Project. Zachary Kaplan is an investigator at the Government Accountability Project who has worked as an investigative reporter. Christos Nantos is a prosecutor of the Court of First Instance, working as a justice counselor at the Permanent Representation of Greece to the European Union in Brussels. Vasilios Petropoulos is a lawyer specializing in economic crime. He also serves as an assistant professor of criminal law and procedure at the University of Athens. Sjorn Schomburg is a lawyer specializing in white-collar and transnational crime. He primarily defends clients in extradition matters, both at the national level and before the Court of Justice of the European Union. Ashu Sharma is Group Investigations Manager with Anglo American and is also Executive Head of Advisory for the Association of Corporate Investigators. Glenn Sorrentino is the Executive Director of Science and Design Inc. and serves on the Board of Advisors to Distributed Denial of Secrets. He is also a former military whistleblower. Amiros Joni is a comparative lawyer by training and serves as head of unit at the European Anti-Fraud Office, overseeing administrative investigations concerning integrity of European funds. Franz Wild is an experienced journalist who led the Bureau of Investigative Journalism's Enablers team for 3 years. So just from even that briefest of introduction, you can see the deep experience and wide array of expertise that our panelists bring to our conversation today. So our first session really is looking at the role of leakers and investigative journalists in exposing malpractice, the legal and ethical implications. And really here, what we're trying to do is dive into a little bit more the nature of leaks, the information, sort of what the sort of content is there in process. And then in our second session, translate that really into legal opportunities for action with the judiciary. So I'm going to invite our panelists to jump in at any point where they would like to sort of offer some remarks. But I thought I'd start us out with kind of really just a foundational question, just if you could offer your perspectives, if you'd like. And this is really trying to just, again, anchor the relevance of leaks. And so what would you identify as the specific relevance of leaks in countering illegal or unethical practices, especially in relation to financial malpractice? So if anyone would like to just sort of start us off, you can just raise your hand or turn on. Franz?
Sorry, hi. I was struggling to unmute, which is remarkable 4 years after the pandemic started. I'm going to be turning myself into a giant cat any second now. Sorry, back to the question. So what's so essential about the leaks is that as journalists sort of so I think Panama Papers were 2016, weren't they? Basically 10 years ago, it was incredibly difficult to come by information that really goes inside an operation, inside a money laundering operation, inside corrupt transactions. You're essentially reliant on sources who kind of have the guts to share information. But once you establish the kind of bigger leaks, you could actually start, rather than being reliant on a specific source sharing a specific set of information, you've got the whole thing, and you can start establishing connections and identifying paper trails, identifying financial relationships all on your own, and to really uncover corrupt relationships. That's the key. So it's really completely revolutionized how we do things. I'll keep it at that because I think we're supposed to keep it short.
Thank you. Scylla.
Yes, hi everyone. I just wanted to put a dot on the I to say that leaks without, well, in this case, I'm a bit partial, obviously, but without journalists looking at them are basically a blob of millions of documents, and they are very difficult to say. I mean, some of them say very little. You need people who actually go through these papers for weeks, who fact check them, who cross-reference them with open sources, who interview people, who go to the field, and who do a lot of work to actually finally publish something that has a meaning to readers, even not who are not as expert as you, everyone who is in this room now, but maybe other normal readers who may not know what a tax haven is, and you have to translate that for them. And before you translate them, you actually have to understand what a board meeting is saying, minutes are saying, a financial statement are saying. So just to make sure that when we talk about leaks, we know what we are talking about, and this is a lot of documents that by themselves have sometimes very little information. You really need the extra work, and I know that Mary mentioned that the Panama Papers whistleblower is working with the government of Germany in Hessen and other provinces. So other investigators are doing the same thing that journalists did, a few years ago. They're doing the same with the Pandora Papers. And so I think what has changed in the past few years is with with internet and the digital revolution, whatever you want to call it, it's the amount of documents that journalists have to go through. But leaks, or these kind of sources have been used by journalists for many years. So I guess the medium has changed, and so the techniques sometimes have changed, but then eventually journalism has remained the same, and we do the same things that we used to do maybe 20 years ago. So I just wanted to clarify that. And also wanted to say that in terms of journalists, ICIJ collaborate with some reporters who face daily threats to even just go through those documents, who cannot even have those documents on their computer because they face prison and other threats, even from their own publishers. So we should also acknowledge the work of those people working in less privileged situations.
Thank you. Ashu.
Yeah, so the leaks have been quite interesting because they've changed the dynamic, so to speak. Corporations have been expected to abide by regulatory expectations globally. There are, teams, multiple teams around, but many corporations are hampered by structure. And a lot of organizations are decentralized. The financial side of things have now been introduced to a new guard. So in the past, the view was, well, the regulators are there, we'll play ball with the regulators, and I think we're okay. But now with the leaks, we've got a new guard. We've got someone who comes along and says, actually, I'm not sure you are following the rules, and I'm not confident that you are going to continue following those rules. So I'm now going to step up and let the world know. And I think that's really put the financial industry and maybe the non-financial to a certain extent, although they haven't been hit so much, it's mainly the financial institutions, but it's now put them on alert that, okay, we could be put under the spotlight. And the question, of course, is, has the financial institution knowingly or unwittingly facilitated financial crime? Now the leaks come along and say, we think you have, and now the institutions are proactively looking at this to say, actually, we don't want to fall foul because the leakers will make sure that we'll get caught. So I think pretty much the dynamics have changed over the last 5 to 6 years.
Thank you. Tom?
Well, I think the heart of your question was why are leaks so important? And the answer is very fundamental. Leaking is the safest channel for the flow of evidence. And that's why virtually all whistleblower laws protect leaking, lawful leaking of protected activity, protected speech, designated misconduct. The European Union Whistleblower Directive specifically states that if somebody who makes an anonymous disclosure is exposed, they have all the anti-retaliation rights. Virtually every whistleblower law in the world protects confidential disclosures, which are just leaks through proper channels, because it's essential to maintain the free flow of evidence. I think the relevance for financial misconduct can best be illustrated from kind of a surprising source. People who are leaking within corporations in defense of corporations. Fraud against corporations is a very serious problem. And ironically, PricewaterhouseCoopers did a survey of that, which confirmed that it's extremely 40% of corporations concluded that fraud against them by internal employees was a serious threat to their operations. But the PricewaterhouseCoopers study also found that leakers within the organization, just making anonymous disclosures to hotlines, were responsible for exposing and catching more fraud against the corporation than internal compliance departments, auditing departments, and law enforcement combined. And that conclusion has been reinforced by the International Association of Certified Fraud Auditors. These are the people who are the lifeblood of accountability, and whistleblowers are. And if we can't have anonymous leaking rights for whistleblowers, the flow of evidence is going to severely dry up.
Italo?
Thank you. It's an honor really to be involved in this discussion, and I would like just to link to some items that have been touched by Sheila. I'm here, I'm representing the Italian FIU, but I'm representing a financial intelligence unit, and I will focus on a specific type of disclosure that is different from leaks, but that is important to give input to investigations and judicial proceedings. And I would also like to highlight how this kind of disclosures, I'm referring to the suspicious transaction reports, that have to be filled by obliged entities in a structured way under international principles and at European level under specific regulations, are to be channeled to the national FIU, analyzed from the financial point of view, and then they can give input to investigations and judiciary activities. It was recalled the tremendous number of information you have from leaks, and the problem to translate information contained in the leaks in evidences and in useful information to give input. And I would to highlight that the international principles, the international framework for combating illicit financial flows sees also the structured field of the financial intelligence produced by the FIUs to give input to investigations. From the other hand, and I would also highlight the importance of leaks, although they are different from the suspicious transaction reports, the structured suspicious transaction reports. I would just recall that it was starting from the Panama Papers that the public opinion had the real awareness of some important issue, such as the transparency of the beneficial ownership, for example. And I can remember that the Panama Papers, due to the attention, the widespread recourse of to corporate vehicles to circumvent tax transparency and anti-money laundering regulations. And I also would like to recall that it was starting from the Panama Papers that not only FIUs and anti-money laundering authorities, but also institutions such as the European Union, the European Council and Commission started to analyze the problems in some fields. I would recall that in December 2017, after the Panama Papers, the European Parliament approved the final report of the PANA Committee that was accompanied by a lot of recommendations for the European Council and the Commission to improve a lot of specific fields. And it was started from the growing awareness that the Panama Papers contributed to have to all the institutions on how to improve effectiveness in action also in cooperation among anti-money laundering and anti-corruption authorities, and how to reach a greater convergence in functions and powers of institutions. So just to conclude, I would like to highlight the different channels by which investigations and judicial activities can be launched, and also the importance of leaks in improving also the institutional activities from this point of view. Thank you.
Thank you. So we have 5 in the queue: Zachary, Amadeo, Mary, Mario, and Basilio. So we'll do those 5, and then we'll move on to our next question, because we have so many important topics to cover here. So Zachary, next to you. Zachary, we can't hear you.
Sorry, that was very dumb. I clicked my video instead of my mute. So sorry. What I was saying is that I think, and I'm saying this with the caveat that I don't have that much visibility into the ICIJ network, which is what I think most of the journalists here are part of. I've only worked with y'all on Dubai Unlocked as part of that project. But for me, both in terms of the sheer amount of data that has become available and the tools in the last few years that have been created, both in terms of big data processing like ALIF and Seamless Horizons, which are two, one was created by a group called OCCRP and the other by a group called C4ADS, that are massive data processors, and then some new kind of metadata reverse search tools for verification. The amount of data, at least on my end, compared to when journalists first started working on the Panama Papers, it feels like there's just and maybe I'm curious what the other journalists think, but there's a massive increase in our ability to process these millions or tens of millions of documents and make sense out of them, compared to with, again, you can have the same 200 journalists working on it, but you can get so much more done these days. So that's my sense.
Yeah, Mary.
Thank you. To your question, I just wanted to sort of draw a little bit upon the significance of leaks and how it connects to illicit financial flows, to say that I think it's important to look at who these leakers are. And although we don't always know their identities, and as Tom rightly pointed out, that's what's most protective. Because we don't know their identities and they're safely able to leak this information, we're starting to see that they come from law firms, they come from big accounting firms, which really is exposing the role of enablers. And I think that's something we haven't seen before, that behind some of these major frauds and tax avoidance schemes and tax evasion schemes, there are not just the folks who are presidents and dictators and royalty in England who are using these services, but it's actually getting a tax advantageous situation, but it's actually the law firms and the accounting firms. And that's sort of what we're seeing sort of behind those levels, sort of that dark web. So I think that's one of the most significant parts to me, is exposing the role of the enablers here, the roles of the law firms and the accountancy firms, and this sort of web.
Thank you, Mary. Mario.
Maybe was me, Diane.
Sorry, you're right. You popped over on my screen.
No,
go ahead, Amadeo.
It's okay. It's okay. I will be very quick, and just a few remarks. First of all, thank you for the invitation. That is really very welcome for me, even more because I'm from the area of Napoli. So also, if virtually, I'm almost at home. Just a point. I'm very happy here to represent also the voice of defense lawyers, criminal defense lawyers, because as defense lawyers, maybe we have a sort of privilege, let's say, because at the same time we can represent leakers, victim of leaking, and maybe defendant against leakers. So we can have a various perspective. Maybe we can understand from the various point of view the issue. For sure, coming back to the relevance, the phenomenon of leaking and of whistleblowing is of great relevance today, because as we know, also in Europe nowadays we have a directive regarding whistleblowing, and we have a lot of legislative tools to defend whistleblowing and also leakers. But at the same time, we know, and as worker of the legal sector and of the criminal sector, we know very well that sometimes whistleblowing and leaking are part of some power game. They can be used as instrument of pressure. Leaking can be used as a tool for battles between powers at a national and international level. That is clear from my experience of criminal lawyer. That sometimes also leakers that can seem really noble with the aim can be used sometimes also as instrument of powers struggles. So as a lawyer, we have to stress the importance of the respect of the rule of law and the rights of the defendants, also with this kind of issues. And even more, also we know, Mary remembered LuxLeaks, we know that sometimes also leakers come from a law firm or maybe accounting firm. And sometimes it's important to stress also that leaking is fine, and defending leakers is important, because leakers can help to create a better society, and also can foster the public debate on really key issues in the public debate. But not always leakers can be defended until the end, because sometimes leaking is the fruit, is the end of also a crime. Because also in the LuxLeaks, we know also the decision of the Grand Chamber of the European Court of Human Rights. Finally, this changed the point of view of the chamber, the normal chamber that said that there was not violation of Article 10 freedom of expression. So it's very complex. It's a very complex argument. It's a very complex issue, and we need to debate in it and to face it, understanding the complexity of the phenomenon. Thank you for now.
Thank you. And now Mario.
Thank you, Diane. Hi, everybody. I would like to stress 2 points. First of all, I would like to answer the question was about the relevance of leaks. I think leaks are relevant because they lift the veil over financial crimes and over financial malpractices. Economic crimes, tax offenses are usually complex crimes, and they're usually perpetrated thanks to the contribution of professionals, and such as lawyers or financial advisors or accountants. And leaks lift the veil over the contribution of professionals. So I think this is why the reason why they are so important, one of the reasons why they are so important. And then I would like to just give you a few remarks over a second topic. I think that we will go through this topic in the second session, but Tom, I think earlier, referred to the European Union Directive 1937-2019 on the protection of whistleblowers. I think that there is a need of regulation for especially tax whistleblowers. And without an adequate system of protection for whistleblowers, anonymity will continue to be the main option for whistleblowers. But the problem is that anonymity affects the usability of the information collected, at least in the criminal trial. So I think we will go through this topic in the second session, but I think that we should stress the importance of a uniform regulation on whistleblowers. Thank you.
Thank you. Vasilios.
Thank you very much, Diane, and thank you also, Costantino, for inviting me in this great panel. I just wanted to add something to what also Amedeo pointed out before. I think that, of course, whistleblowing leaks are of enormous importance, and especially with view to economic crimes. But I think that a core problem from the judicial criminal practice is related to their relevance as the evidential use of them. I think that it should be ensured that this evidence should be adhered, should be obtained according to certain reliability protocols, perhaps. I think it should be avoided, for example, for the whistleblower to interfere with the original material without ensuring that it has been securely preserved, for example. Because I say that because I remember that there was a case of a whistleblower who had downloaded several bank files onto his computer, which then were subsequently processed into several Excel files without ensuring this secure download. So after that, it was of course impossible to access the original files of the bank because it was in another jurisdiction. And in general, it was a huge point on whether it should be, I mean, the reliability protocols, if they had been followed in this case. And that's why I think that perhaps for managing evidence, the same protocols that apply in several cases of internal investigation should also apply in these cases in general, as to stress what also Amedeo said before, that also the rights of the defendants should be protected. Thank you.
All right, Glenn, you want to pop in for a sec before we move on?
Yeah, thanks for letting me raise my hand a little late. Thanks for having me, everybody. I'm Glenn, running Science and Design, a nonprofit. You know, the way that I see, you know, the relevance of leaks is, you know, they expose secrets, right? I think that the effectiveness of how that information is leaked ultimately depends on the relevance of the leaks, right? In my example, I was in the military, and I had a commanding officer that was misusing money, and, you know, having me as kind of like the proxy of doing that. And my route was to go through official channels of you know, going to my commanding officer, and then, you know, so on and so forth. And you know, nothing was really solved. I was hazed, and you know, it wasn't an awesome, you know, experience. And I think that kind of just highlights the problem that a lot of people who want to do responsible disclosure, you know, face. It's, what do we do? How do we do it? When do we do it? A lot of people have touched on you know, laws to protect whistleblowers. I think in theory that's all well and good, and there's this paradox in America, at least, of, you know, having the institutional framework that suggests we support whistleblowers, and then conversely, the whistleblowers not receiving or feeling like they've received as much protection because of a loss of career, a loss of reputation, of, you know, so many things. So it's a tricky balance, and I think that any opportunity that we can have to guide someone who feels like they have information that they want to share into the best channels and the most responsible channels for sharing that information is I think still an ongoing problem that we're trying to solve.
Thank you very much. So for those of you following along with the line of inquiry, I'm really going to sort of combine questions, the next questions 2, 3, and 4. And those are, I think what I'd say is a slightly more precise question about receiving and working with leaks. And so this is really the question. And we've had several of you touch upon parts of this before. I'm thinking Scylla, Vasilios, Italo, and Zachary. I think parts of your answers touched upon it, but I just wanted to take a moment and be precise about how are leaks typically received, and then sort of what are the methodologies that you all are using or have been seen used in investigating the leaked documents, thinking about digital forensics, the use of AI. So the question is how received and then how investigated, essentially to sort of verify, secure, et cetera. So open it up to a little bit more on that question. Zachary.
Okay, so to start, like in terms of receipt or in terms of verification, I think is where I'll go. It's a lot for me of metadata from personal information included in the leak. It's very simple these days. If there's, say, a phone number in a leak or an email, you can use that to find the social profiles of the person who it's attached to. And let's say, like we had we're just thinking of on Dubai Unlocked, there was a Yemeni general, and we had his email, which you can then use to pull a LinkedIn account and then run facial recognition on the photo on LinkedIn and match it to the news articles about this general, and then we know we have the general. And so I think when you're dealing with a large data set, then Dubai Unlocked, for example, is the last project that I worked on like this, is that you're having to go piece by piece and verify each one within the data set. And then there was a lot more of matching, for example, the names of the people in the properties to tax registries from Dubai to, again, verify that the leak was actually accurate. So there's a lot of using tools and public data to check the leak. But I'll let other people talk about, I think, the handling and security. I think I'm not exactly, there's probably people who are more of experts on that specifically here.
Thank you. Scylla.
Yeah, I can talk about how we do it at ICIJ. So we've been working with leaks since 2012, I think, and the way we, there are several ways to, they come to us. I mean, as journalists, you know, journalists have sources, so sometimes a source would provide the information. In other case, Mary mentioned that Arij use a secure channel. ICIJ also those secure channels like Secure Drop and other kind of ways to get info from people totally anonymously. But then once we receive the leak, we have a tech team that is specialized in ingesting the information into a platform that ICIJ has created that is secure, of course, and also allows journalists from everywhere in the world with a secure access to go through the information. Before ICIJ gives access to journalists, the ICIJ team will vet the information, and we will do that by cross-referencing some of it with open sources. So obviously, you can find Gazette, even in the BVI or even in tax haven. Sometimes you have a minute information out there that can at least give you a hint that the information could be true. Then obviously you can verify by checking OFAC sanctions, that give sometimes personal information about people and so forth. But then this is just the beginning, right? Because then it's the journalists coming in and then they have to do all the other work. The leaks are just one of the sources that are usually used to then get to the facts. You use leaks, but then you use interviews, you use so many other documents, you use people who are in the room that will know more than you. So just to yeah, this is what we do at ICIJ, and what our partners, have been doing for at least 10 years. So we work with people who have expertise, piecing together everything so that the leak, even if we don't know who the leaker is, sometimes we don't even care, to be honest. We know what the information tells us, and that's all we need. We need the facts. We don't need who provides the facts sometimes. Sometimes it's interesting to know. Sometimes, yeah, it's not really necessary. One interesting thing is the Luanda leaks, for example. I know William Bourdon is here. We know who the leaker is, but the story is Isabel dos Santos and all those things that had never been uncovered before, thanks to the information that he provided. So I'll let other people talk.
Thank you. Glenn.
Yeah, I can just briefly talk about how leaks are received. So I work with Distributed Denial of Secrets. I serve on their board of advisors, and leaks are there is no one way that leaks are received, and sometimes leaks are received through, you could say, official channels, like whatever you set up in order for someone to reach out to you, whether it's Secure Drop, Global Leaks, Hushline. But sometimes it's, through Telegram, and it's like, you see these hacking groups that it's amazing because, a decade ago, whenever the Snowden leaks happened, the size and impactfulness of these leaks, you didn't see it all that often. And now with, better technology, faster internet, it's kind of exploding, and we can't really keep up. And it also highlights, the value proposition of a tool like Secure Drop is such that you can receive leaks wherever the sources, come from, and handle those leaks in a safe way, so it doesn't, destroy your network, your computer, all the computers attached to it, so you don't infect yourself. And I think that the tools to receive leaks, there's a real opportunity to make this more streamlined, easier to use, to encourage more people to participate in a safe way, and potentially in a more consolidated way, because really, like, there's not one way that we can just monitor everything. And it's also what adds to the complexity is the size of the leaks. The size of the leaks and where they're stored, and the redundancy of those leaks. Our servers are always under attack, and that's an issue, having backups for our backups for our backups. And it's also a lot of money for that much storage space. For the methodologies, just briefly, there are tools, Zachary touched on it a little bit, Aleph, DDoS has an instance called Hunter of Aleph, and you can go create an account and do a more in-depth search of the corpus of information without having to download terabytes of data. And I think that the tools there's a huge opportunity. The thing that I think we struggle with, some of us, not everyone, I think in the civic space, is the funding required to build such systems. It's non-trivial, and there's more and more tech out there that can help, whether it's OCR, whether it's some fancy stuff that we think about with LLMs, but there is a really big opportunity space there, because now we can move beyond just structured data. And that's one of the great things about financial data, is oftentimes, like, you get data dense tables and just pages and pages, and it's more machine readable. And now with advanced technologies, we can turn unstructured data into structured data, and that just opens up a whole area, I think, that used to provide a really big obstacle for people trying to investigate this type of information.
Thank you. Simon.
Hi, actually, Sheila and Glenn covered some of the point I was hoping to make, but I would just put an emphasis on this idea of who the leakers are here, because I think often in these discussions, the abstract concept of a leaker, it's very easy to think of someone who has a troubled conscience, a white knight who is wanting to bring truth and justice to the world. But the reality is often more complicated than that, and sometimes very ugly indeed. There was mentions of hacks as well. So if journalists receive information that is anonymous, we don't know if it's hacked, and these are all complex things to navigate. I think Sheila was making the point that the quality of the information, it becomes what you really rely on at the end of the day for your public interest judgments. But it is also important to understand or have some assessment of who it is who is whispering these confidential things into your ear, or into your hard drive, because there are cases where media have been manipulated in legal disputes. I think one of the previous speakers mentioned, there are power struggles and leaks occur in power struggles. I think that's very much true, and we have to be alive to that. These are some of the things that we think about as journalists. But I think it's really healthy to have an idea that leakers are complicated people rather than these white knights who are here to save us all. And I'm all in favor. When you see the quality information come through, I'm all in favor of leaker whistleblower rewards. I think it makes complete sense. I don't know why Europe is so hesitant on this point, because the quality of information now that can be put on a memory stick is transformational, and I think it's silly to be in the 21st century to be coy about that.
Thank you. Christos.
Thank you very much for the floor, and thank you very much for giving me the right to participate in this fruitful discussion. What I would like to point out is that we can make a distinction between illegally obtained evidence and simply notitia criminis. That is an important point. Why? We are aware of the reluctance and the hesitation of many law enforcement authorities to get in touch with these leaks, because they are afraid that they might be condemned, let's say, as committing a crime for violating the privacy or the secrecy, for example, the tax secrecy. What I would like to say is that, in my opinion, the prosecutorial authorities and the other law enforcement authorities can get in touch with this material in a legal manner in order to be informed about the crimes committed. They have the right to be informed. They cannot use this matter as I don't know if they can use it. It's a matter of weighing among the seriousness of the crime and the severity of the breach of the privacy and of the secrecies, tax secrecies, and so on in most of the countries. It is a matter of domestic law in most of the countries. But in general, I think that if we tackle this information as notitia criminis, then we can put them inside the criminal procedure and start an investigation. And afterwards, we have specialized authorities such as FIO units, anti-money laundering units, and these authorities are not bound by in most of the cases, are not bound by the tax secrecy, for example. And they can search and they can begin their search from zero according to this information provided by the leaks, and they will then try to prove. And maybe we have a problem at court of the fruits of the poisonous tree, but not a problem of direct use of illegally obtained evidence. Thank you very much.
Thank you. Tom?
This isn't so much about quality control, but in response to some of the points that have been made.
Tom, you're frozen? You were frozen?
Am I still on my internet connection?
Now you're good. Now you're good.
Oh, good. Okay. It's certainly true that leakers or whistleblowers who go public can have hidden agendas and be engaging in power games. All freedoms can be abused. And that's why a leak should be a starting point for further investigation rather than an ultimate conclusion. But the fact that this freedom can be abused is that's just the basic facts of life. Secret transmissions of the truth, they're the lifeblood of society's checks and balances, whether it's investigative journalists, public interest watchdogs, NGOs that are watchdogs, or law enforcement agencies. It's a new whistleblowing and leaking are maybe new media terms, but they're a timeless phenomenon. As long as we've had organized society, law enforcement has been dependent on secret transmissions of evidence to start their investigations. We've always had confidential sources as essential for effective law enforcement, and confidential informants who are getting rewards from authorities in order to obtain evidence. This is a fundamental cornerstone of accountability in every society, regardless of ideology. And our challenge is making sure that it's used responsibly, effectively, and safely.
Thank you. Amira?
Thank you, and thank you also for inviting me for this event. I hope you can hear me. Yes, okay. I change my micro. So yes, thank you, because this topic is really very relevant for our office. I work for the European Anti-Fraud Office, which is also called OLAF. For those who doesn't know, we investigate any type of fraud and irregularity affecting EU money. And I don't have exact statistics, but I would say that approximately 1/3 of our cases are open from based on information coming from private sources, while 2/3 are coming from public sources like auditors or other. And I think the source of information coming from leaks is especially relevant because in the sector of financial crime, the idea is always to hide the crime. The fraudsters who target EU money are very often professionals of it. So they know very well our rules. They also know how we control the spending of the EU funds. And therefore, it's very difficult for us to have initial information on a case. And this is why one of our only possibility to learn about corruption or fraud affecting EU money is leaks coming from inside. Now, it is possible that whistleblowers come directly to OLAF. This is more common, especially when we have internal investigations, which means that we investigate wrongdoing within the EU institution, the staff of the EU institutions and bodies. Here we have really a procedure for whistleblowing, also an obligation for the EU officials to inform OLAF. And we have also the other part, which is the biggest number of cases, which is external investigations. And here we can receive the data directly from the leakers, or we can also receive it via investigative journalists. And I would like to highlight really the role of investigative journalism for OLAF, because very often we receive information which is already structured, which is already analyzed, and then we can go with our tools and collect the evidence, which can be later on used in procedures at court, whether it is civil procedure or criminal procedure. And you also ask about how we analyze, how we use that material. So, or with the help of investigative journalists, there is a preliminary analysis that then we can confirm with our forensic tools. Or we can also receive directly huge amount of data. So for example, in OLAF, we had an analysis also of the Panama Papers and other big data. We have our IT tools, which use artificial intelligence and other, where we can cross-check with open source databases, with databases from the European Commission, and then our analysts come with the analysis report, and this can be later on used also as evidence. Thank you.
Thank you. And Shorin, I'll go to you, and then we'll go to our next set of questions.
Yes, thank you. My name is Søren Schomburg. I jumped into this very recently on behalf of Vanya Kostaramas of ECBA. So also from my side, thank you for having me in this discussion. Perhaps just a very quick question to Amira. What you just described is very interesting to me as a lawyer, not only because we often face the defense side from, for example, when Panama Papers have been leaked and questions of admissibility of the evidence arise, but on the other side, of course, forwarding this information to Olaf, for example, raises the question of what is your cooperation with the leaker and or the journalist? Because when I think of how a journalist, for example, would approach you, what's his interest? His best interest would probably be to have the big scoop. So possibly they don't even want to involve you because they risk their own publication, right? On the other side, they may depend on your additional investigations and insights to have better proof of their source and their leak. So they even may want to cooperate with you. What's your experience on this? This would be very interesting to know how you cooperate with them and how willing they are to support you and cooperate with you.
So should I react directly?
If you'd like to, yes.
Yeah. Well, complicated question, of course. Where is the interest of the investigative journalists of OLAF, and also where to find the balance? My experience is that the investigative journalists who were the source of my cases are people who are also worried about the public interest. So it is envisageable for them to put on the side the immediate information to public and respect the interest of the investigation. So it happens that when we ask, please keep at this stage the information confidential, there is a respect of it. Of course, there is also an obligation, or there is also the interest of public information. This is why we don't disclose on our side what we are doing. However, when it is public interest, so for example, that we have now procedures on when OLAF case is closed, there is a certain right of the public to know about the cases. So we will communicate at least that we close the case and which type of recommendation. And then this is something which can be also used by the journalist. So I don't have a universal answer, but I would say that our cooperation is usually good because we are on the same side. Yes, it's a matter of finding the balance and communicate at the right moment also.
Thank you for that. So now I'd like to kind of, and for again, those of you following along with our line of inquiry, sort of really combine questions 5, 6, and 7, because I take them to really be about the reporting side, the reporting process in all of this. A number of you commented on the great magnitude of materials, data, information that's coming in. And so the way I would take the sort of reporting side of it as sort of a 3-part, can hit any part you'd like. How do you choose? You've got all of this coming in when you're thinking about or reporting. How are specific cases or issues selected, or how should they be selected? So that's the focus side. What do you focus on? How do you ensure responsible reporting? Given that this information may have legal or ethical implications, where does that fit into the process? And third, there's a bit of a tension. There might be an interest in public dissemination versus ensuring actionable legal proceedings. How does that influence choices in the reporting side? So we're overall about reporting, focus, what issues, how do you do it responsibly, given legal and ethical implications? And then that sort of tension, if you see it or don't, between a goal of public dissemination versus a goal of actionable legal proceedings at the end of it all. So you can pick any part of that you'd like. Scylla?
Yes, I'm gonna talk now because I have to leave in 10 minutes. I apologize. I just wanted to say that, ICAJ has a specific mission. Maybe it's different from other news organizations, as we only work on international projects. So obviously we would tackle, let's say, a leak if it has information on more than one country, let's say. But in general, obviously the primary the criteria is this in the public interest or not? If it's just gossip, we are not interested, of course. Second, we have to verify that what's in the leak is factual, and these facts are true, that we can corroborate this in other ways. And then we treat, let's say, for us, authorities are one of the sources. We do not cooperate with law enforcement. After we publish, sometimes we get requests from law enforcement agencies asking to help. In general, we only work with journalists. And so we try to be as impartial as possible, because even if here, the representatives of judiciary bodies, etc., are in some countries, there is a lot of politics involved. So as journalists, we don't want to be involved in that, or be perceived to be involved in that. So I think, and obviously we want, as in ICAJ, we always think of, we want to report on broken systems that affect people. We are journalists after all, so we do this for the people. We don't do this as, we are not activists. We don't want action. We want to inform people as much as possible. So, thank you.
Thank you. Stefano.
Thank you, Diane. Can you hear me? Yeah, okay. First of all, thanks for having invited me to this very interesting discussion. I am a European delegated prosecutor, so I work as a prosecutor. And I try to give you an answer, to the 3 questions that you have posed, and also to expand a little bit some thoughts that, for example, Christos shared with us some minutes ago. I see the problem in this way. This is my perspective as a prosecutor. From one side, we have the journalist world, the world of journalists, who they rely on the sources, confidential sources, and it's up to them how to treat, how to receive, how to assess these information that come from confidential sources. And from the other side, we have another world, if I can put it like that, which is the world of law enforcement agencies and of public prosecutors in general, the judiciary world in general. Each world has its own rules, its own needs and particularities. Sometimes they are in contrast, sometimes they walk on the same path or in a parallel path. What I think is that, in my opinion, the European directive on the whistleblower is maybe the first, one of the first, I don't know if it is the first, but for sure one of the first attempt to link the two different worlds, to build up, in order to build up a bridge between the two different worlds, because the European directive on whistleblowers lays down a regulation on how the leakers may report information, remaining and keeping their identity secret, but in a way that can trigger an investigation, a formal investigation immediately, because it is ruled. There are the conditions have been written and laid down by the regulation and by the national legislations that in the European countries have implemented the directive. So we have to take into consideration that we have different needs and different two different worlds that are combined, linked by a special framework, which is the European legislation that has recently ruled the role of whistleblowers. Without that legislation, the two different worlds, as it happened in the past, used to work, in a separate way. Sometimes it happened that some information coming from the journalist world triggered an investigation, because as Christos said before, explained before, we can also open a case as law enforcement or prosecutor offices, just for example, by reading a news on the newspapers, then we can open an investigation. But before the attempt, in my opinion, well done and well built up to put the different words in contact with the special legislation, European legislation about whistleblowers, we used to walk in a parallel, sometimes separate way. Nowadays, thanks to the effectiveness and the importance of this new legislation, the European directive, we can combine the different needs, keeping in mind and maintaining the different rules and particularities. We have, as a prosecutor office, we have already opened investigation and cases coming directly from whistleblowers using the channel foreseen by the national legislation inside the European agencies and bodies. So it's a very effective channel of transmission of communication that I hope will work even better in the coming future. Thanks.
Thank you. Tom.
My contribution is more on your first question, Diane. How do we choose what leaks to use? And I can share government accountability projects criteria. The first is whether we believe in them, do an independent verification. The second is whether anyone else is working on this. Are we a unique resource, or just piling on and repeating other people's work. The third criteria, though, is the most significant, the bottom line, consequences. Consequences is the magic word in our criteria for who to help. How much of a difference is this information going to make? How is it going to have an impact on society? And with respect to your question, what about the conflict between publicity and legal outcomes? Well, for us, there is no conflict. The whole point is to make a difference. So if publicity would be helpful, we team up actively with the media. If premature publicity could sabotage a good faith government investigation, we bypass that partnership. But we don't bypass it too often because the media, in our experience, is oftentimes the watchdog for an effective fact-finding process in legal investigations. Evidence can't be covered up if we've shared it with a reporter who asked the government investigator what they're going to do about it. It's a good way of letting the government know that they can't suppress an issue because the media is asking them questions about how they're handling that particular issue. They can't keep it under the radar screen in their official record of the resolution. So it's an invaluable partnership, but it's one that's dependent on contributing to consequences that help society.
Thank you. Franz.
Yeah, I think just coming back to the kind of public interest point, I don't know if I've actually seen any leaks, significant leaks. So obviously you get kind of individual leaks about X person, sort of tittle tattle, but the leaks we're kind of talking about, you don't really get that in a scenario where it's not really in the public interest. And actually, I mean, I'm based in London, and we often talk about the UK as a sort of problematic jurisdiction from a legal perspective when it comes to publishing. And that's true. On the flip side to that is because it's so treacherous here, it means our standards have to be very high. And that's not sort of trying to say journalists here are any better than anywhere else, but it's just that the strictures are incredibly tight. So we kind of do very stringent public interest tests right at the beginning, about halfway through, and again before we publish. So I have to say everything I've seen in that space is from my view very much along those lines. I also think there are always different actors who are very important in this process. So, you know, the whistleblower, obviously the whistleblower may have an axe to grind, may have a vendetta, but it's obviously our job to understand that where it's possible to identify it, and then to work with that. They're never, as Simon said, they're never, or they're usually not a white knight. They're complex people. So you kind of have the whistleblower, you have the media, journalists, you kind of have the people who are more on the campaignery side, you have the sort of prosecutors, and various other players. And quite often it actually works best to have several parts of these working together. And I think William Bourdon wasn't able to make it today, but a few years ago, I worked on a project where we kind of had whistleblowers from the DRC whose interests were defended by PLAF, William Bourdon's organization, which is based in Paris. They had a huge leak from Afriland, a Pan-African bank, about allegations of money laundering and sanctions busting. And they were then also working with Global Witness. And then on the media side, they were working with me and a few others. I was at Bloomberg at the time. And together we were able to cover different grounds. So PLAF, for example, were able to ensure that the whistleblowers were looked after, A, from a security perspective, B, from a immigration perspective, because they had to flee the DRC, so had to find asylum, seek asylum in the EU, and then from a legal perspective, obviously, Global Witness and us were able to kind of do the investigations, and Global Witness were then also able to kind of put together briefings that were relevant for OFAC, State Department, and other institutions or regulators, prosecutors. So actually, and that I think has changed quite considerably in the last 10 to 15 years. I see a lot more people in the media, but also in maybe on the side of prosecutors who are far more open about working in that way, in a common interest, in a way that doesn't blur the lines, because obviously it's really important that independence is maintained amongst all those various organizations. But it is possible to do that. And you know, if we as well, part of at the Bureau of Investigative Journalism, the impact of our work is front and center. So it is actually part of our mission to brief people after we do the reporting, and sometimes even before we publish. So for example, if we think we've got a case of sanctions busting, well, actually I'll use a real example. In the case of the Dutch football club Vitesse, we identified, this was actually part of an ICIJ project, Cyprus Confidential, where we identified that Vitesse had been acquired largely with funds from Roman Abramovich. And, you know, Vitesse's finances had been investigated twice by the Dutch football authorities. But they clearly didn't have the information we had, and because of the leak, we were able to put some pieces together and figure out the real story after we published. The Dutch authorities asked us to talk about it, and naturally for us it's essentially another form of publishing. We briefed them and told them what we knew. And we saw that very much as being part of what we're doing. We didn't see, naturally, Scylla earlier talked about kind of being part of a political dynamic. You have to be aware of that. You have to navigate that. But it doesn't mean you can't, you can't talk about the work. You can't talk about your findings. And there's absolutely, I think, work to be done in terms of having those kinds of briefings.
Great, thank you. Italo.
Thank you. Just 2 or 3 thoughts again from the perspective of financial intelligence unit, and I would focus in particular on question 7, when the information enters the public domain. I think a lot of items have been touched this afternoon, and in particular the content of leaks. Are they always notitia criminis? I don't think they are not always notitia criminis. They, in particular, in big cases of leaks, such as the Panama, they are, in my opinion, just transparency exercises, maybe. And we have to be very careful on how to deal with these pieces of information in terms of course, use of them as evidence, but also in terms of quality of the information leak. And again, I think this raises the need to filter the information, the need to assess and to be sure they refer to possible illicit activities or just to suspected behaviors. And as FIU, as FIU that is in charge to give input to investigations through its financial analysis of STRs, we experienced that in case when the information entered the public domain, became public, we experienced a lot of STRs just sent on the base of the mere presence of the names in the leaks and in the information issued and public, and not based on anomalies or anomalous behaviors based on subjective or objective profiles, the profile of the subject or the suspicious activity performed. So I think this is a big issue for all the institutions that are in charge of analyzing information and then of using information in investigations and then in judicial proceedings.
Thank you. Mary.
Thank you. I wanted to circle back to the question about, is there a tension between the goal of public dissemination versus legal proceedings? And the way I think yes, there can be. And it's been very helpful to hear from Franz and Tom about, how there are so many stakeholders in these kinds of investigations where you've got NGOs, like Global Witness, you've got the leakers, you've got the investigative journalists, you've got the prosecutorial authorities. And so from my perspective, I work exclusively with whistleblowers who are bringing information largely as confidential informants to various US government regulators who pay them for that information. And in terms of the tension, I think it's all about timing. And what can be most protective for our whistleblower clients is obviously gaining the financial protections of a potential financial reward. But also, and that comes with going to the government first. That is very helpful. I know the journalists on the call are not going to want to hear this, but it's very helpful because obviously the prosecutors would like to conduct a covert investigation to begin with. It can be very advantageous that they have a head start before journalists and journalistic outlets publish this. It can help them with their prosecutions to have a head start and to have that information not revealed. It also has the very protective benefit to the whistleblowers, as Franz alluded to, in terms of the defamation laws, which are not as protective of sources and whistleblowers in the UK as they are in the US, but even in the US, it can be very protective for a whistleblower to have a government investigation that has corroborated what the whistleblower has had to say. And that information, it's a much better posture for a whistleblower to be part of an investigation that ended up in some government enforcement action that was triggered by their information, right? Then they're in a much safer place in terms of the types of defamation lawsuits and other things and tactics we've seen big corporations use against whistleblowers, including suing them for violations of, trade secrets and confidentiality agreements and defamation. So yes, I think there is a little bit of a tension, both in that the prosecutors would like a head start, and also a little bit of a tension that it can be safer for a whistleblower to start with providing their information to a government regulator before they go to the media, for the reasons I just described.
Thank you. Simon.
Thanks. I'll be quick as I can. Yeah, I just wanted to make the perhaps obvious point that that there is something in between sort of prurient gossip on the one hand and actionable prosecution outcomes on the other. And it's often in that gray area in between that a lot of journalism happens. So don't forget, we don't have investigative powers beyond that of any other ordinary citizen. So often we end up with a situation where we've got a bundle of very suspect behavior, lots of red flags, and it's about whether we can construct a story that will be legally safe to publish. Now, particularly in Europe, the UK and the EU, the threat of privacy actions in those kinds of circumstances can be very prohibitive, and that is restricting a lot of investigative journalism getting out into the public domain, which is patently in the public interest. But it's just another thing that's hampering the dissemination. But I would say, you know, another good outcome for journalists is exposing policy loopholes. You know, you saw that with the FinCEN files and LuxLeaks, as Mary mentioned earlier. But I mean, one of the things, the just final point I wanted to make illustrative perhaps is in the US, there was a fantastic leak of tax documents of the most wealthy individuals in the land. And that was an amazing window inside to the very specific ways in which super rich people were confecting their affairs so that they would be borrowing stuff that was from corporate vehicles in a way that absolutely minimized or extinguished all tax liabilities. Now that kind of specific reporting, to my mind, and I'm not a lawyer, I think that there's no way that would get past the privacy threshold in the UK, and that is and Europe, and that is a big restriction on what we actually get to put in the public domain and disseminate.
Thank you. Alessandro.
Okay, sorry, I was not able to rehabilitate the voice. So good afternoon, everybody. Thank you very much for having invited me to this very interesting conference. I don't want to repeat things that has been very interesting things that has been said to now. I want to just add some information about my experience as the first Olaf European Anti-Fraud Office spokesperson at the beginning of the century, that today is represented by Amira, that already explained what Olaf is. My experience was very tricky because from an aspect that has not been touched a lot until now here, when leaks can involve investigation services. In the beginning of the century, the beginning when Olaf was created in 2000, we were victim of instrumental leaks of documents that had as a purpose to undermine the independencies of the office. It was a young body at the beginning, so we fight a lot against this fact. In this time, fake news didn't exist, the name fake news, but we faced, with my small team of communicators, investigators and communicators, I faced to this phenomenon. And I would like to stress also this aspect that we have to take in account in this discussion. And relating the relationship between investigative services and journalism, I personally created, with the support of my former Director General of Olaf, Mr. Brunner, a German prosecutor that who passed in 10 years after. An OLAF anti-fraud communicators network that is a unique platform, is still a unique platform of responsible communication between law enforcement agency, custom service, and also at the time a part of the judiciary. Was a platform where we discussed, we try to put together experience in this kind of activities, also in cooperation with the media, profiting of the fact that there's investigation against the leaks of OLAF documents that has the purpose to jeopardize our investigation, oblige us to open an investigation. And a German journalist complained against this, and there was a very, maybe the most part of the colleagues today are too young for remember the so-called TILAC case. It was a case that arrived until the court of Strasbourg. And Olaf didn't have any legal problem, but the Belgian authority was condemned by the European Court of Strasbourg. So we arrived to the conclusion that in an ideal world, media and law enforcement should have the same target. So that is the true to be watchdog of legality. But we know by experience that we don't live in an ideal world. So we have to be careful about the misuse, the instrumental use of leaks. And in 2024, we have to be careful also of hybrid threat. And so hybrid threat is something that can be in our democracy, can be made using the freedom of the independence of our investigation and the freedom of our media. So it's a very tricky situation where we have to balance these two aspects. And I put a big question mark, for example, is quite of elephant in the room, the so-called Qatargate. And Qatargate, as readers of the information on the media of this investigation, we don't have a lot of proof, a lot of evidence, but the leaks or the instrumental leaks using information coming from secret services of third countries has surely undermined the credibility not only of the European Union, but also of democracy. If you are interested after, I don't want to take a lot of time now, I can explain speak you about a memorandum of understanding that following this TILA case in 2005, we signed as OLAF Anti-Fraud Communicators Network. So it means in the name of all the investigative service, European investigative service, with the International Federation of Journalists. At the beginning, they attacked us because they complain on the fact that Olaf undermined the freedom of press or investigative journalists, etc. But then when a very proud General Secretary, Aidan White, an Irishman, understood the issue, and I repeat, in that time, fake news didn't exist anymore. Today would be easier to explain what happened. We realized this memorandum in order to do our job, investigative services and media, in a proper way, but also on the basis of ethical standard that we all have to add.
Thank you. All right, so our last two interventions now, Ashu and Samantha. Ashu?
Thank you. So somewhat controversially, this is the old jurisprudence question. What is legally correct versus what is morally correct? I think the reality is that when I was in law enforcement, if I wanted to get a warrant, it was very clear that I couldn't do a fishing exercise. I had to be very specific about what I needed to get. Otherwise, the judge would not give me the warrant. With leaks, fishing is the order of the day. We don't have a specific concern about a specific individual. So we look at the Panama Papers. Here's a list of thousands of individuals who have done something that might be legally correct, but we believe is morally incorrect. And so that leaves corporate investigators in a very tricky situation, and corporates generally. If we leak one customer's data, we are in breach of GDPR. But if every customer's data is leaked to the press, it's okay. So I think from that aspect, it becomes a very interesting question. And that is why we get those tricky situations like the FinCEN files, where the individual who leaked those documents is now went to prison. Why? Because she violated government law with regards to those SARs, and corporates themselves would feel aggrieved by it, but it's now down to perception. The journalist would perceive as this is the moral duty to indicate that perhaps the banks are facilitating financial crime, but from a legal perspective, there are expectations and requirements on those involved in that process, and that has been breached. I think that's where leaks become incredibly tricky for corporate investigators, but also for prosecutors as well. And that is that balance. How do we achieve that balance?
And Samantha.
Thanks. So I just want to say, the public dissemination of a disclosure can really drive an immediate public reaction, while, of course, legal proceedings can lead to long-term systemic change. And this combined approach can make an impact, but it's problematic that the legal landscape is so complicated for responsible whistleblowing and reporting, and it's inconsistent and unreliable. So journalists, to be responsible, really need to understand the risks to their sources, and there's almost an obligation that's created to produce a reporting product that makes a big difference and captures the public interest and captures the government interest, and even to be the first in time. Otherwise, a whistleblower could be left in the legal lurch. And so a battle exists between the laws that protect trust and secrecy within the professions like the accounting and legal professions, and the rights of whistleblowers who still have a risk criminal and civil prosecutions. So there is a need to strengthen anti-SLAPP legislation. The case of the LuxLeaks whistleblowers really illustrates this. When we had SLAPP suits filed against the whistleblowers, the European Court for Human Rights Guja judgment created a standard that's still being used, and it contravenes best practices. The court balances the need to protect the freedom of expression with the employer's rights, using this really convoluted and excessively vague and unreliable test that creates a lot of uncertainty for whistleblowers. So they have to show that their disclosures were essential, new, and previously unknown information, and whether they were necessary in a democratic society, which must be convincingly established. And there are some instances where the employer really should suffer detrimental effects, given the nature of their illegality and misconduct, and that has affected the public interest. But for the whistleblower who's seeking to make a difference, published articles that fail to capture sufficient public interest or government response might leave a legitimate whistleblower in the lurch. And the court also provides a motives test. And of course, the best practices of motives really should be irrelevant for whistleblowers. So the use of criminal proceedings to punish the disclosure of confidential information is fundamentally incompatible with the exercise of freedom of expression. But that's the system that we have today. And the European Court for Human Rights acknowledged this, but it also acknowledged that in many instances, the conduct of the person claiming the protection potentially afforded to whistleblowers may legitimately amount to a criminal offense. And so while the European Union Whistleblower Protection Directive, I think is a big step in the right direction for Europe, I think this goes to show how the courts play a role in filling in gaps and creating standards that are unreliable when they're applying these legal tests without a lot of clear specification of the burdens of proof for the whistleblower. And I think that this creates a challenge for people who are in the tax industry or the auditors industry or the legal industry as well, who are seeking to blow the whistle, and they have different international or national ethical standards and guidelines that are instructing them on what to do, or maybe they feel compelled to use channels in the absence of having a legal framework. But we have to acknowledge that the legal frameworks and infrastructure is still very far behind when you have many countries who don't even have these safe channels or comprehensive legal protections for whistleblowers in place. And that almost forces some people to go public with their reporting, but people have to do this at their own peril. So, I think that there is some fundamental loopholes that still exist that make leaking and whistleblowing extremely dangerous today, and places a burden on journalists to use every tool that they have to, redact information appropriately, to work closely with the whistleblower to protect their identity and confidential information, and to make sure that they are making an impact with their reporting to show a clear public and government interest. They almost are obliged to make a difference and have some sort of government response to outweigh the likely slap suits that are almost par for the course these days.
Thank you. I'm going to draw us to a close on our session 1 questions. If you were following along, in terms of questions 8, 9, and 10, we did cover 10, turned out, in the answers that we received to my very first question. We talked about sort of the value of these kinds of leaks. Question number 10, sort of thinking about the difference between illegal and ethical issues, and sort of the relevance. I think, and for me, that was picked up a bit in the answers to questions 5, 6, and 7 as we thought about how to focus resources, how to make choices about what to prioritize. What I would like to hold to the next session and encourage you to think about is the end of part question 8. And really that's thinking, we've had some discussion already about the tension perhaps between the role of public reporting and the goal of actionable legal proceedings. That was done sort of in the reporting side. Question 8, the last part, really gets at the sort of relationship between the media and the sort of the administration of justice once we have proceedings underway. And so if you have ongoing legal proceedings, thinking about the impact of ongoing media reporting at the same time, trial by media, et cetera. So kind of hold that thought till our next session. But at this time, I would like to invite any of the officials joining us from the various locations, if they have any questions they'd like to raise at this time. Okay. All right, well, while you're pondering, in case you'd like to, I'd like to just raise one of the questions we did get from our other audience more generally. And it really goes to something, and in part, Samantha, your last remarks touched on this a little bit as well, as have others during the course of our first session, which is about the protection of whistleblowers. And the reason that they're trying to do their disclosures anonymously. And so the question's really, I'll just sort of paraphrase, if we want to protect democracies and public interest, are there better ways for disclosures to go forward, and how do we at the same time sort of protect the disclosing person, typically an employee, thinking about the difficulties they may face ranging from financial to mental health. And so if any of you just have a few thoughts on sort of additional ways or examples you've seen that have been particularly helpful for those engaging in these kinds of disclosures. Soren?
Yes, thank you. Perhaps just coming from a defense perspective again, what the point you're raising is, of course, of key importance. And I think there's several issues to distinguish here. Number one, being the actual act of disclosure and the potential conflict with the laws on, well, government secrets, but also on business secrets, tax secrets, and what was just described under GUJA by the ECHR ruling, but also in the decision on LuxLeaks, which was the Halle decision by the court just recently, which is very lengthy exercise and therefore difficult to predict what this balancing exercise will end up with. So indeed, there is some degree of uncertainty to that. But that is only just one aspect of the whole thing. And I think it has also been mentioned, but let me repeat it quickly, because from a defense perspective, it is, of course, the utmost relevant part of it. That is, what is the leaker? We want to incentivize the leaker to come forward. And that leaker ideally would be someone who comes from the inside, right? So if you have someone manipulating whatever, LIBOR, let's take an old example. If someone manipulates LIBOR, then ideally you would want to this person to come forward and to report on what was done, what has been committed. However, to the extent that at least the European legislation on that is provided, well, you have one big issue, and that is, well, the reporting itself is protected under certain circumstances, but the actual act of that was committed initially, you have very different systems of how you can provide certain safety to and safeguards to the whistleblower that was participating in the initial offense, him or herself. And please don't get me wrong, I'm not saying that there should be a carte blanche for everyone who's participated in crime. But on the other hand, if we do want an efficient system of whistleblowing, there should be some mechanism to provide some certainty to those who come forward, which is something that is probably in the best interest of many people. So again, I'm not saying these people should go completely unprosecuted, but just as a very practical example, if someone comes to you as a lawyer, it's always very difficult to predict what's going to be the outcome of the whole thing. Is he going to go to prison? If so, for how long? Well, that's going to be one of the first questions that someone in that situation will ask.
Thank you very much. All right, so I'm going to bring our first session to a close. We'll take a 5-minute break. So just a quick stretch, and then we'll rejoin for session 2, where we're going to take this sort of really rich background picture of leaks and sort of all the component parts, and really now move to thinking about how can all of that leaked information be brought into the legal sphere, turned into legal action, and used by the judiciary. So please join us again in 5 minutes. Thank you.